Welcome. We begin our study of the rule against perpetuities, often called RAP. This rule exists for a crucial policy reason: to keep land and property marketable. Imagine a vibrant, active real estate market where owners can buy, sell, and develop property freely. This dynamism benefits society immensely. Now, contrast that with a situation where ownership is locked away by ancient conditions, perhaps tied to events centuries in the future. Such stagnation prevents the productive use of valuable assets. The rule against perpetuities steps in as a vital check within property law. Its sole purpose is to police future interests, ensuring that ownership rights are clarified within a reasonable timeframe. It prevents grantors from exercising perpetual dead-hand control over property long after they are gone, thereby promoting economic efficiency and ensuring that land remains available for current generations to use and improve. Now that we understand the policy driving the rule against perpetuities, let us state the rule itself, which is the cornerstone of this entire topic. The classic common law definition is precise and must be memorized. No interest is good which must vest, if at all, later than 21 years after some life in being at the creation of the interest. Notice the critical word here: vest. This rule is fundamentally a rule of vesting, not possession. We are concerned with when the uncertainty ends, not when someone actually takes the property. To apply this, we must break the rule into three essential components. First, the requirement of vesting. Second, identifying the measuring stick, which is the life in being at the time the interest is created. And third, the fixed period tacked onto that life, 21 years. We will examine each of these elements in detail shortly. The rule we just stated applies only to certain future interests that are inherently uncertain. Our next critical step is identifying precisely which interests trigger the rule against perpetuities. Generally, the rule against perpetuities targets contingent interests. Let us look at the primary triggers. First, contingent remainders are almost always subject to the rule. Second, executory interests, which shift or spring ownership, are prime candidates for violating the rule. Third, vested remainders subject to open, like a remainder to a class that has not yet closed, must also be tested. Finally, certain powers of appointment must also comply with the vesting requirement. Now, what interests are exempt? Interests that are already vested and certain, such as a vested remainder in the grantor, are safe. Furthermore, interests held outright by charities are typically exempt from this common law restriction. If an interest is not contingent, or if it falls into one of these specific exceptions, the rule against perpetuities does not apply. Now that we know which interests are subject to the rule against perpetuities, we must define the critical time limit, the perpetuities period. This period is the measuring stick used to test validity. Lives in being plus 21 years. A life in being, or measuring life, must be someone alive, or in gestation but later born, at the exact moment the interest is created. For a deed, creation happens upon delivery. For a will, creation happens upon the testator's death. Crucially, this measuring life must be someone whose life or death can actually affect when the contingent interest vests. If the vesting event could possibly occur more than 21 years after the death of every person alive today, the interest is void. Think of it as establishing a starting line, the moment of creation, and then drawing a maximum allowable time window extending from that line, the duration of the longest relevant life, plus a fixed 21-year safety buffer. We have established the measuring stick. Lives in being plus 21 years. But how do we apply this stick? This is where the rule against perpetuities becomes notoriously unforgiving. The crucial methodology is testing based on possibility, not actuality. At the precise moment the interest is created, you must look into the future and ask, is there any conceivable way, no matter how remote or absurd, that this interest could vest outside that measuring period? If the answer is yes, the interest is void immediately. We do not care if the event actually happens later, or if it is highly probable it will vest on time. The law demands certainty at the outset. Think of the contingent interest as a ticking time bomb set to the perpetuities deadline. If that bomb is not guaranteed to be disarmed, that is, guaranteed to vest, before the timer runs out, the entire interest is voided right now. This strict, possibility-based test is what leads directly to the famous traps we will explore next. Now we must confront the traps that arise directly from this strict possibility test. These traps rely on two fundamental, and frankly, unrealistic, legal assumptions that the law forces us to make at the moment of creation. First, the assumption of the fertile octogenarian. The law presumes that any person, regardless of age or medical condition, is capable of having more children. An 80-year-old is legally capable of procreating. Second, we have the unborn widow scenario. If a grant refers to the spouse of a living person, the law assumes that spouse might not yet be born at the time the interest is created. Let us see this in action. Imagine a grant, 2A for life, then to A's children who reach the age of 25. If A is alive, A is our measuring life. But A could have a child today, and then have another child 10 years from now, after the measuring life dies. That second child might not reach 25 until 25 years after the measuring life dies, violating the lives in being plus 21 rule. Because this possibility exists, the gift to the children is voided immediately. We now shift our focus from the assumptions about people to the structure of the grant itself, specifically when dealing with executory interests. Remember, these interests often follow a defeasible fee simple, meaning they take effect by cutting short a prior estate or by filling a gap after the prior estate ends naturally. Consider the grant, to A, but if X happens, then to B. If the condition X happens, A's estate is cut short, and B takes possession immediately. This is a shifting executory interest. The problem arises when the condition X might happen too remotely. If the gap between A's estate ending and B's estate beginning is potentially longer than the perpetuities period, the interest violates the rule against perpetuities. We are looking for a gap in ownership that stretches too far into the future. If the possibility exists that B's interest might vest outside of lives in being plus 21 years because the triggering event is too remote, B's interest is voided immediately, leaving the original grantor with a possibility of reverter or a resulting trust, depending on the initial language. When an interest is void under the rule against perpetuities, the property reverts or results back to the grantor or their heirs. However, courts sometimes employ judicial modification techniques to salvage the grant, provided the original grantor's intent can still be honored. The first technique is called slashing. Slashing allows the court to strike out the offending, excessive language in the conveyance. For instance, if a grant said, to A's children who survive A's death or 25 years thereafter, the court might slash the, or 25 years thereafter, clause, effectively changing the condition to simply, to A's children surviving A's death, which is valid. The second technique is si pres, meaning, as near as possible. Si pres allows the court to reform or rewrite the language to fit within the perpetuities period. This is often done by substituting a fixed statutory period, like 90 years, if the jurisdiction has adopted a modern statutory rule. These techniques aim to prevent the harsh result of outright voiding when the violation was minor or easily correctable. While judicial modification helps, many states have moved beyond common law tinkering by adopting statutory reforms. The first major trend is the wait-and-see approach. Instead of voiding immediately based on remote possibility, courts wait to see if the interest actually vests within the perpetuities period. If it does, it is valid. A more definitive change is seen in the Uniform Statutory Rule Against Perpetuities, or USRAP. USRAP often replaces the complex measuring life test entirely, substituting a fixed period, commonly 90 years, during which vesting must occur. This provides certainty. Now, for your bar exam takeaway. Regardless of whether you face common law or a modern statute, remember this core principle. Always test the validity at the moment of creation. Look for any conceivable way the interest could vest too remotely based only on the facts known at that time. That possibility, however remote, is what triggers the rule.